Good evening, everyone, and welcome to a special meeting of the Landlord Tenant Ad Hoc Committee for July 6, 2022, meeting starting at 5:38 p.m. My name is Peter Zovak, and following the agenda, can we please have the roll call?
Committee Member Jennifer Schultz-Bertolet.
Here.
Committee Member Razmi Grigorian.
Here.
Committee Member Victor Herpetin.
Yes, here.
Committee Member Teal Marchand.
Here.
Committee Member James Son.
Here.
Committee Member Isabella Tavanian. Committee Member David Zargarian.
Okay, so we'll let the record reflect that Committee Member Tavanian is absent. Second on the agenda is the regular business agenda. May we have the report, please?
The agenda for the July 6, 2022 special meeting of the Tenant Landlord Ad Hoc Committee was posted on June 30th, 2022 on the bulletin board outside City Hall.
Very good. Third on the agenda is approval of minutes. Item 3 is approval of minutes from the June 1st, 2022 special meeting of the Landlord Tenant Ad Hoc Committee. Has the committee members been able to review the minutes and
Mr.
any comments,
Zovak,
questions?
I believe we have not circulated that, so we will bring that back along with the minutes of this meeting to the August meeting.
So we'll have 2 sets of minutes brought back at the next meeting?
Correct.
Okay. Very good. Moving on, item 4 is oral communications, and this is communications for items not listed on the agenda. There is a 2-minute time limit. Committee members may question or respond to the speaker, but there will be no debate or decision. Do we have first any callers online?
We have one caller on the line.
Okay, let's take the caller first, and then I believe we also have.
Is the caller calling for an agenda item, specific agenda item, or just general comments?
General comments.
Okay.
Hello?
Hello?
Mr. Milano?
Yes, I'm here.
You're on the air. You have 2 minutes.
Thank you. Mr. Solveig, members of the committee, my name is Herbert Milano. I was reviewing the documents that were given to you back in April 27, and it shows that there are about 10,000 units, to my calculation, that are either not single family, but rather units that are less than 5 units, and units of 1 and 2 units, which are several thousand. And altogether, there seems to be about 10,000 units that do not necessarily carry the same level of impact as those that the ordinance does for units over 5 or more. So here's the question that I'd like to pose. When a tenant rents,
We lost him. There are no other callers on the air at this moment. We do have one public speaker here with us today.
Please let us know if he calls back in, and then we'll let him continue, though.
Hello. Ես կխոսեի ապրել, եթե ձեր թիվով լիդեի, բայց շատ քասլբե բրդեր, իսկ տեսնելուց բրսում էր, ոնց որ վույվեր դեր ժամանակին բրսում, դրա համար ის չեն ընտրել ձեր մեջ։ Դες որ գերանացում եմ խոսել հայերեն։ Վիկտոր,
I'm sorry.
Can somebody
Yes,
translate her?
if you can speak very, եթե ավելի հանդարտ խոսակ կարող ենք թարգմանենք ձեր ասածը, որտեղ
չեմ
բոլորը
լսում աղջիկ ջան։
Եթե ավելի դանդաղ խոսեք, ձեր ասածը կթարգմանենք. So I think you need to give her 4 minutes because of the translation.
Այդ կադը լավ, ոչինչ։ Շարունակությունը։
She says that can you please state your առաջ ձեր անունը կասեք խնդրում եմ.
Վիկտորը շատ
Առաջ ձեր անունը կասեք խնդրում
իմ
եմ.
անունը Թամարա Մովսեսյան է։
Her name is Tamara Movsesyan, and she's
Victor
just a
Yevena
moment,
is
just a moment,
lawyeress.
just a moment. She said that she was not elected. She had applied, but she had not been elected to be a committee member by the council members.
Երբ որ Մարտասյուն, երբ ես ապրում էի 342 բելբոտի, նոր բելբոտի վրա,
When she was
Իսկ
looking,
դատի էր տվել, իբրև ես տա բարձը չեմ տալիս։
նորից ասեք խնդրում եմ.
Դիտավորյալ։
Նորից ասեք խնդրում եմ.
Ուրեմն, Դավիթ առաջ,
Many years ago,
Մարտասյուն, տատերը 344 բելբոտ։
340 North Belmont, the landlord of that building,
Թշնամության նպատակով,
out of animosity,
իսկ դատի էր տվել,
filed a lawsuit
իբրև ես տա բարձը չեմ տալիս։
to say that she wasn't paying the rent,
Այնինչ ինքը չեր վերցրել։
except that the landlord was not accepting the rent,
Որից տար դատի։
so that he could file a lawsuit, an eviction lawsuit,
Դատեր տալիս,
to evict me from the house.
որովհետև ինքը չեր վերադառնու ռեմոնտ, ռիպար չեր տալիս։
He was not repairing or remodeling the apartment,
Ես էլ բողոքել էի,
and she complained to the city.
իրեն դրա համար տուգանել ես։
As a result, the city fined him.
Եվ ինքը վերջապես դատի տվեց,
Finally, he sued her
ես տա բարձը չեմ
as if she weren't paying her rent.
բայց
But
միջև այդ կոմետը, ես արդեն խնդրել էի Վիկտորը դիտի իմ լոյերը։
But until then, she had asked Mr. Hayarpetian to be her lawyer.
Իրենցալոց ես ասեմ, Վիկտորը շատ տաղանդավոր մերն է,
He's a very talented lawyer,
որը եւ շատ գրագետ է։
and he's very
Educated.
educated.
Այդ լոյերների մեջ դավադավատ, հայ լոյերների մեջ, հատուկ այդ մարդիկ կա։
Out of lawyers, especially Armenian lawyers, there are just a handful.
Դες որ ես շատ շնորհակալ եմ Վիկտորից, բայց ակամ ես իրեն դա ասել եմ։
She's very grateful to Victor, and she's told him that.
Որովհետև շատերը իմ ծանոթներն բայց ինձ ասում են, «Էդ ո՞նց Վիկտորը քեզ վերցրեց»։ Դու
Because many people were saying, how is it that
ինքը հարուստերին է պաշտպանում։
how is it that Victor agreed to sign you on as a client? You're an old lady on a pension, and he typically represents very rich people.
Վիկտորը ինձ վերցրեց, որովհետև Վիկտորը փողից բացի ունի պատիվ, եւ իր պատիվը բարձր է գնահատում։
Besides money, I think Victor has pride, and he values that a great deal.
Հիմա ես խնդրում եմ, քանի որ ես հաստաժողովում չեմ, դրա համար ես այսօր եկել եմ, խնդրել հատուկ Վիկտորից, որովհետև ես գիտեմ ինքը խելոք մարդ է, տաղանդավոր մարդ է, մյուսներին չեմ ճանաչում։
Since I'm not a part of this committee, I've come to ask Victor, and I don't know the rest of you.
Որ հիմա ինչ-որ նոր
Supposedly, there was a new decision that was made that mold is no longer important.
Կարող են բոլդովտուրը տալով վարձով տան, ու ոչ մի պատասխանատվություն դրա համար չունեն,
And landlords don't have to be accountable to remedy the mold.
չնայած մոդի հետևանքով շատ tenant-ներ ստանում են ասմա, հիվանդություն։
A lot of tenants continue to get sick as a result of mold. They get asthma.
Հաստատված է, Վիկտոր դեր գիտի այդ,
That's for certain, and Victor knows it too.
հա։ Հիմա իմ խնդրանքս դա է, Վիկտոր, որ դու զբաղվես քո տաղանդով ու գիտելիքներով, որ այս թիմը նորմալ աշխատի, ոչ թե դեպ աշխատի, ոնց որ որոշ city council-ներ։
She's asking Victor to make sure that this body performs well and not like certain council members. That's what I'm asking of you. I came specifically for that, so that I can ask that of you. Is it time? I'm asking all of you to work with Victor
Ms. Movesian, that's your time.
so that landlords don't surpass their limits. And that tenants aren't forced to ask արդեն պետք է վերջացնենք, ժամանակը վերջացավ։ Okay. Thank you.
Thank you.
Շնորհակալություն։ Այո։ Այո։
Thank you.
Մեկ վարքան սպասեք խնդրեմ։ Մեկ վարքան։ Can I say something? Կներեք դիգին։
Turn your microphone on.
I'm sorry. Դիգին, մեկ վարքան խնդրեմ։ Just one moment, please. Ես շատ ուրախ եմ, որ դուք եկել եք եւ ձեր կարծիքները ներկայացրել եք. I'm very happy that you are here and you expressed your concerns. And I promise you, Victor, myself, and everybody on this commission is exactly committed to do whatever you are requesting. Թե Վիկտորը, թե ես եւ թե մյուսներս բոլորս հատուկ մեր պարտականությունն ենք զգում, որ ձեր այդ ինչ որ կետեր դուք ներկայացրեցիք, անպայման մենք դրանցով զբաղվենք եւ ամենալավ լուծումները գտնենք ձեզ համար։
Thank you so much.
Ես ձեզ խոստանում եմ։ I promise you. Ես խոստանում եմ ձեզ։ Հաջողություն։
Thank you. Okay, so
Getting all of that. You can do that yourself.
we do not have any other speakers, and the caller did not call back in?
Correct.
Okay, so we'll move on to the next item on the agenda. That's item 5, business agenda. 5A, continued discussion of possible changes to the rental rights program. And I'll turn this over to staff and Sipan Zadorian.
I think we're going to, Mr. Zadorian and I are probably going to tag team this. If you recall at the last meeting, we had discussed, we went through the just cause eviction ordinance. There were certain areas that the staff had comments, the committee members had comments. We have put that into a red line, and we shared that with you earlier today. That red line is also available in your packet on your desk if you picked one up. And then also, we can have that up here, but in a summary format, it's in a PowerPoint that Mr. Zadorian is available to walk through. In addition, this would be the time for you all to make additional comments, make changes. If you've changed your mind since the last discussion or had some additional clarity and you'd like to make those comments, by all means, make them today, and we'll go through each point one at a time.
And Ms. Verpettian, we are not necessarily taking a vote on making those permanent changes to the rental rights program. So tonight is not the only night to have a change of mind on something or add another element or discussion point, correct?
That's right.
Okay, so for any member that still is interested in continuing to look at that, we will be doing that.
I think in the interest of moving the committee meeting along, we probably will bring that back at a much later meeting, because I think we want to move forward from these comments, receive them, and then target the outreach at the next meeting. And then if there are summations at the very end, we will bring all of that back together for a wholesale review. But I don't know that it would make sense for us to keep trailing the same items every meeting, because then we'll never be done.
Correct, okay.
Mr. Pittman, I have a request. The email that I received today was supposed to be 10:30. I was hoping that we would have gotten it before today. Unfortunately, my notes, myself, and the email were all.
Committee member, can you make sure your mic's on, please? Thank you.
I'm sorry, thank you. Mr. Varpetian, what I was saying was, I received the email today at about 10:23 a.m. Myself, the email, and my notes from our prior session were in different locations, and I have basically come here from another location without having the ability to kind of gather everything. If it is possible, I don't know what the process is, and of course, with all due respect to my fellow committee members, if we can have an opportunity to review the red line, especially since I, at least myself, had taken copious notes of the prior handout that we had received, and then have a meaningful discussion where we can kind of go through this, that would be much more, I think, helpful for me, yeah.
Yeah, no, we're prepared to go through it line by line. So by no means are we suggesting that we're going to rush the process or not spend the time that's necessary for the committee.
Well, the only thing is that the prior version that I had was the one that had all my notes on it. I can try to see if I have it in my car and come back. But the thing was, is since I hadn't received this until just a couple hours ago today, it's really kind of hard to prepare for a meeting when it's like here and
Yeah,
this is because I didn't even know what was on this agenda until I received the PDF earlier today. So,
And I think some apologies go from staff, because I think
That's
we,
on me. I'm sorry, I should have sent it earlier. All on me. I just didn't realize I hadn't sent it out.
no problem. Like I said, I have no problem having a discussion. I just want it to be a meaningful discussion because I want to be able to look at some of the items that were indicated. I also, again, I defer to the fellow committee members and see their comfort level. If they're ready to proceed, I mean, we'll try to do as best as we can. I would probably try to run outside and see if I've got my notes still with me. But at a minimum, I would first make this request, and then kind of pass it along and see what the rest think. And then we'll go from there.
sounds good.
I concur with my colleague. I also asked this morning, and I received it around 10:30ish, and I had to spend the rest of the day out of my office, and I hardly even had a chance to look at it. So we could discuss a lot of general issues and whatever you present to us, but I would also have a hard time to make a meaningful conclusion of whatever we do.
Just to be clear, the red line isn't new information. It just captures the discussion from the last meeting. So the red line isn't new information that you didn't have. It's a repeat of the discussion, just captured in a paper format.
So basically,
I understand that. My only thing is I would feel personally, I feel more comfortable having my own handwritten notes in front of me.
Of course.
So that I can refer back and forth. This may be a pointless exercise, but like I said, had I had a little bit more notice, I would have at least brought the notes with me. I can do it on the fly, so to speak. I just need to, I would prefer to have them since I spent several hours last time preparing those notes. Again, I have no problem. I'll go out to my car, and if I have it, we can pick up right here. I just want to defer to my other fellow committee members before we proceed. If they're all ready to move forward, then, we'll do the best.
Take a recess if you'd like. We can take a 5-minute recess if you want to go to the car.
Are you comfortable going forward?
I mean, I'm okay going
Are you?
Go get your notes.
Yeah, I'm gonna go take a look and see if I have my notes, then we
Why
can go from.
why don't we take a 5-minute recess? If you could let GTV6 know, we'll just wait for a few minutes.
Okay, we are going to reconvene our meeting from our recess. It is now 6:01. And just we'll quickly describe what's going on is that we do have a red line version of the just cause and retaliatory evictions ordinance. We understand that the committee members have not all had a chance to properly read through it due to the late notice in getting this information to everyone. What we are proposing is that staff go ahead and walk the committee member through the red line changes, and then we'll carry this item over to the next meeting, and any other notes that you may have, and then further consideration of what we've presented can be brought back at the next meeting. That'll be acceptable to everyone? Okay, so then if we can ask staff, please, to walk us through the red line comments that we've generated so far.
So last week, as we discussed the rental rights program, we went through a couple of things, suggestions that staff brought. We listened to your suggestions. These were the points that I believe we discussed, and we didn't get to all of them. I don't believe we got to enforcements and violations. So we're going to go over these points. Lucy has the red line. You have a copy of the red line in your packet. We're just going to go through the options we discussed and basically summarize the discussion we had. So the first thing was the 1-year written lease offer. So we talked about cleaning it up and providing better education as an option. We talked about just keeping it as it is and just improving education and outreach. We discussed removing it completely out of the ordinance, so not having a 1-year lease offer requirement. And I believe committee member Harapetian came up with the suggestion of offering the 1-year lease initially, and then a second 1-year lease for the second year, and then not offering another one moving forward. So those are the 4 options that are represented here.
If I may just correct, the indication not to offer further going forward was if the tenant elected to reject the offer of a lease. So if the tenant accepts the offer of the lease, there should be no issue. Yeah, then in the following year, they should continue to offer the lease.
Okay, and these are the 4 options that we heard. I don't believe anybody else had any other options. Do we want to discuss new options today, or?
Sure.
Ms. Varpetian, are we going to go over any of the definitions by any chance?
Can. I mean, let's maybe establish some ground rules and get your comfort level of how you want to discuss it. We are now summarizing what we had discussed last time and indicating to you where we had received comments. We can continue to do that and give you the entire summary, or I think Mr. Zadorian is suggesting that we could discuss each one of these, get your comments back immediately, and then continue on. Everything is on the table for discussion. So I don't want you to think that staff is somehow saying something should not be discussed. We just want to do it orderly so that we make sure we get to everything and enough time is given to each section. What is the preference? Is the preference that we give you the entire summary, or would you like to comment on each of these sections as we discuss them and then start at the beginning with the definitions again? What's your preference?
Before you decide, we have another presentation where it continues the discussion on some of the points in rental rights, like the relocation fee, the relocation percentage, and definitions. So there's an opportunity to bring up opinions and options for those sections. This is just a summary of last week's discussion. We were planning on continuing the discussion on rental rights and any ideas you might have to improve the program.
So at this point, as we're going through each section, do you want to offer any ideas now or bring them back later?
My personal preference would be to kind of go through the ordinance as it's written.
Okay.
Start with the preamble and then go through the definitions, and do we have any comments here? If not, then we can simply move on and
Okay.
eventually get to the sections that may have, where we have the red line that's indicated in the handout that we have. But I think there was, at least at the last meeting, I had made a comment or two that there was a few items in the definitions that I would like to also be clarified.
Okay. So is the preference then to start at the preamble and make our way down? We've got one person who's expressing that as a preferred method of process. If no one else has a preference, then we'll follow that.
I guess I'm worried we're going to get bogged down in minutia, but if there's concerns, I don't want to, not allow you to have your concerns. I just wonder if this is going to take a long time.
Well, let's give it a shot, and if it takes too long,
Fortunately,
then.
that's what happens when you have an ordinance, is it's that minutia that kills it, potentially. Some of it may be very easily, we can glaze over, but I noticed, for instance, a few of the things I noticed, there seems to be some similarities here with using language that is more typical with commercial tenancies than residential. And so, if really what we're concerned about is a residential-based ordinance, why have definitions that?
So I think what we're just going to do is read item B into the record as well, and then we can discuss both A and B together. Go ahead.
We have a caller on the line for A and B.
Okay, let's read B into the record.
Item 5B, review June 1st, suggested changes to rental rights program.
B1, B2, B3, B4, all of it, please.
5B1, 1-year written lease offerings. 2, just cause evictions. 3, relocation fees. 4, banking.
Okay. Now let's go to the caller, and then we'll come back and start at section 1 of the ordinance. Yes.
Mr. Milano?
Yes.
Hi, you're on the air. You have 2 minutes.
Thank you very much. I have prepared separate comments for 5A and 5B. I don't know if I'm going to have 2 minutes for both, or if I can basically discuss them with 4 minutes.
It would 4 minutes.
Thank you very much. The first suggestion that I would like to make, if the topic of the 1-year written lease offering is being discussed, is to give you an observation that the leases have been around for many decades, and they have been created primarily for the protection of the landlord. And so when we had a significant amount of vacancies for many, many decades until about 40 years ago, we needed to keep a tenant in for the first 12 months. And after that, it was fine to basically go into month-to-month agreements. But now that the market has changed, and basically landlords have a choice of tenancy, and tenants have a lot of difficulty finding a place, I think that locking in a tenant due to a lease agreement may be unfair to the tenant, and to a landlord it would not be such a disadvantage not to have a 1-year lease. What we want, I think, is stability for the renter. If we were to give them 12 months assurance of notification of what their future rents will be, it would probably accomplish the same thing. And I think it is perhaps a good topic for discussion. The second item that I wanted to bring has to do with the relocation percentage. Right now, we have about 5,000 units that are exempt due to the fact that the ordinance exempts 1 and 2 units. And you had another 5,000 with a lesser, should we say, penalty, to the landlord in case they were to request the tenancy to be terminated due to no cause of the tenant. My suggestion is that if we were to not have any exceptions whatsoever, no exemptions, that it would be much easier for us to create simplicity such that no landlord would be overburdened by the complexity of the ordinance, and that it would be self-monitoring. I submitted a document to both the City Council and to Mr. Zovak, but I forgot to send them to each one of the members of the committee. But basically, it's a simplification concept that says a 2-year notification of termination of tenancy, not due to the cause of the tenant, and a $2,000 a year for every year that they've been a resident. A simplified version that is easy for the tenant to remember, easy for the landlord to remember, will prevent a significant number of legal action by a confusing and complex ordinance. If it is self-monitoring, it can go a long ways towards its effectiveness. And I tell you this as a landlord, that it would be a much simpler way for us to carry forward a policy of simplicity at every level. Thank you very much.
What staff will do is that,
Drop off again?
no, he completed his remarks.
4 minutes? Oh, he's done? Okay.
Yeah. Mr. Milano mentioned an email that he wished that he stated he had sent to the committee. What we'll do is we'll forward that to the committee, and then if there's any interest in any of the ideas, then that could be brought up at the next meeting. So with that, we'll just ask staff to continue with the presentation.
I don't think we're gonna do a presentation. We're just gonna go through the ordinance page by page, and if there's any comments anyone has, how do you
So-
want?
So let's start at the top, and we've got the entire ordinance here. It starts with 9.30.010, the legislative purpose. We could stop at each of these and receive comments.
I actually have a comment, if that's okay.
Go for it.
It's called just cause eviction and just cause and retaliation evictions. Can we change the name to rental rights program or something along those lines, since it's not just cause anymore, if the committee wishes?
One thing that we really need to make sure that we are clear is to, again, clarify whether this is regarding the residential leases and tenants or includes the commercial tenants also. Because obviously there are two different things, and we either have to separate them, or if we are combining them together, we have to address them correctly. Most of these talk about residential and they don't talk about commercial. So let's clarify it. Is this a lease for, I mean, whatever this ordinance is or whatever rules we devise or recommend the council, are there only for residential leases or includes commercial also?
So in the legislative purpose, it does specify, the council finds and declares that there is an increasing demand for rental housing in the city of Glendale, which has resulted in critically low vacancy factor. In addition, the increasing number of residential rental housing units have substandard living conditions and reduced service. So that it doesn't at all speak to commercial. And as a result, it is applicable only to residential. I don't know that we would need to clarify that any further.
Yeah, my comment was because we were changing this into a, well, I mean, there was a recommendation that it's rental or tenants' rights programs. Commercials are also tenants. So we have to clarify. Yes, I do read the first paragraph, and it's obvious there. And, you know, despite the fact that I have some comments on it, and that's probably not relevant at this stage, but again, when we have the ordinance, it has to be clear that this is regarding the residential, whatever we want to call it.
So I'm hearing you suggest that the title should be Residential Rental Rights Program.
I'm saying if the ordinance concerns only the residential units, then yes, it has to, the title will also have to include that.
Any other comments on that section, on the title?
I would rather call it, you know, the civil code calls it the hiring of property. Tends to be a little bit of a cold definition, but I also like to be consistent with the state. And so having it something, and again, we're just shooting off the side of the cuff here, residential hiring of property rules with regards, these are the rights of both sides. It's not just the rental's rights, but also the landlord's rights as well. So I think if we're dealing with it in a more generic name, similar to what the state uses, but I do agree, I like the suggestion that we change the title.
Any other comments on that section?
I would go with rental rights, just like staff recommends. Rental rights.
Okay. So we'll make note of that, and then we'll incorporate all of these into the red line for next time. Now we're at the legislative purpose. Mr. Gregorian, I believe you said you had some comments in this section.
No, No, I prefer to defer my comments to later.
I have a question with the preamble. Since the purpose indicates that currently, I mean, look, this is a cut and paste of the prior legislative purchase, which was set forth years ago. Do we still have, I just want to make sure that it's current, rather than we just glaze over it. Is there an increased number of residential rental housings that have substandard living conditions? Is the city actually seeing that? And reduced services?
So this is not a cut and paste. This is the existing from decades ago,
Yeah, it's the
right?
existing.
So we can definitely make changes to the section that, to the legislative, especially since we're reviewing it again. We can definitely, maybe at the end, when we're done with the proposed changes, let's say if we're removing a section or recommending an additional section, maybe that's when we could revisit the legislative purpose and really try to make the purpose reflective of the amendments that we're proposing.
Right. And again, my purpose is, or my comments are intended to say, look, we understand why this commission was put together, and we understand what we're trying to do. I just think that it would be nice to have the most current stated purpose to reflect what it is that we're here for. Are we here because there's really a serious problem with uninhabitability, or are we doing this to really bring the residential housing market into balance in the city of Glendale? So if if city staff has information that suggests that that is a valid ongoing issue, then of course that should be stated in the purpose. If it doesn't, then that should also be the case. Paragraph 3, for instance, was also originally written at a time when we did not have the state's enactment. And I think, again, there should be, from a standpoint of any sort of future judicial scrutiny, some interweaving language of why this should override the state and how that sets forth in light of 1482 now being in existence, since this is now being essentially refreshed at this point. And I have a feeling 1482 is going to be here for a while anyway, so.
I think
Ms. Barbetian, actually, when you asked me about that, I didn't want to speak about it, but now that the subject has come up, that's exactly what the wording here is. Quite wide, and it's very general, all-encompassing, but some of them may not even be as a major issue. And if a unit is really not habitable, then that's probably the under the authority of the building department or the housing department to make sure that they compel the landlord to make the unit habitable. And to put that into a ordinance with residential rental rights, yes, of course, all residents need to live in a habitable building. But again, the enforceability of it is not up to us, the ad hoc committee members, but the building department or all the relevant other city departments. The zoning department or whoever else has authority over this.
Okay, so we did add, I did add a line that we will revisit the overall legislative purpose section once we have incorporated all of the amendments and we have a better handle of what it is that we are trying to address.
I think I had one comment. I think maybe with regard to the habitability, I think that was in here as it relates to the retaliation section of this. So maybe that needs to be just a little bit more clear, perhaps, that's that's why that's in there, I think. So.
We could certainly fine tune it and update it.
Yeah, I mean, the simple statement could be is, there's obviously a concern here that with inflation and rising costs and things like that, and with the limitations of housing, the stated purpose could very easily be that tenants could potentially be victimized by, excessive rent increases or frequent rent increases that could be a harm to the family or to occupants that are residing in the city of Glendale. That alone, I think, satisfies what we're looking for. But if there's no burning situation with substandard units, why have that in there? I mean, and of course you have other retaliatory protections by 1942.5 of the Civil Code. So, is that language at this point just superfluous?
And again, we could take a look at that and try to fine tune it a little bit better, depending on what it is we're regulating.
I think it personally needs to be in there, to be honest, just in case. And with that said, if we can have, and if I can bring this up at this moment, so the committee can be clear of everything that happens with tenants that some people may not be aware of, is there an email address as well that the committee, that people can email their issues to the committee versus rental rights, the other office? Will we have an email that's for this committee?
I don't believe that, individual committee email addresses are provided now.
Not individual, but to
I think there
email,
is
a general email, like if
can
someone
look
in the
into
public
that.
has a concern.
Yeah. We can look into that. I think if there typically is, for every committee, there is an email, a general email address. So we'll
think
look
that's a
into
great
that. If we don't already have it, we'll set that up.
Generally, we use any rent-related issues, goes to rent@glendaleca.gov.
Right.
And then Adita forwards it to the appropriate person. Adita handles that hotline email.
Of course.
So rent@glendaleca.gov.
So we need our own email. I
Correct.
think we'll get a better picture, the committee in general will get a better picture too of what's really happening with tenants.
We can ask ISD to set that up.
And my suggestion would be to, again, publicize it as much as we can through public service announcements and all the, other means that we have, so that the public will be aware and they would participate.
Are we ready to get to the next section, .020, definitions?
Yes. I don't know, do we want to start in a particular order? I don't want to just speak up out of order or anything like that.
I don't know that, I don't think we have to, yeah.
I was just going to say, do we want to kind of go down, starting from that way or this way? And say,
Sometimes one committee member's comments sparks a response, so.
Okay, so one of the first things I noticed was the definition of base rent. It appears to me that this is the language that comes a lot, that is seen more typically in commercial tenancies, comes out of the AIR lease. But to say that the base rent includes anything that for parking, storage, utilities, water, garbage, or any other fee or charge associated with a residential property, that's technically not an accurate statement, because you usually have your base rent, and then there are, for instance, there are some landlords that utilize what's called the RUBS program, and so the services, the utilities change every month. So there is no set number. It's kind of that plus this. I think we can simplify this by saying, when you sign up to rent an apartment, you say, I'm going to pay X dollars per month. And if it's inclusive of everything, then that would make sense. But if it's not, for instance, there's late fees that also come into the picture. There's other little dynamics, increase in security deposit, which is technically another charge that could be associated with an annual increase. You also want to raise the amount of the deposit. I would ask that city staff take a look at this so that it's simple. That's it.
So we can discuss that. What we were finding, and this is why base rent is defined a little bit broader, is that what we would have is, $1,000 a month for rent, and then the rent would be raised, say that 7%. And then parking would be separate, and it would be $100. And then all of a sudden, the base rent would remain what it was, and parking would jump to $200. So in order to capture that increased value of that 7%, the definition for base rent included all of the expenses that would go along with living in that unit. Certainly, we can make that change and call it, base rent is just the rent that you pay, and then, the add-ons include cable, internet, parking, storage. That was the rationale for why the definition appears that way. We can certainly discuss how it should appear differently.
A suggestion, how we've resolved this in other situations that I've dealt with, is we can say that any charge that is set essentially by the landlord. So if the landlord sets the base rent at $1,000 and the landlord sets the rent at, the parking at $100, then it's clear that it's the landlord which initiates that assessment, whether we want to call it rent or something else. But if you get a bill from, Glendale Water and Power, and there's a fluctuation, and these third-party service providers say, your new proration is X. They're tier charges and all this other stuff that's always in the works. Then I would think that in a situation like that I think we would all agree that that's not the landlord trying to be sneaky. That's just kind of the way it is. Same thing with the late fee charges, which have to be based on a liquidated damage under 1671 for the purpose of, what's an unspecified amount that could be assessed that's allowable. That, again, is kind of tied to that. But when you start doing this any other fee or charge, the dog...
It's too general.
Yeah, the dog makes a mess and the landlord has to send someone to clean it. That's technically under the rental agreement can be a fee that's assessed to the tenant because it was the tenant's animal at that point in time, or their pet. If you assess that charge, is that now illegal,
Do you have a different title for, do you have a specific title for rent or charges that are set by the landlord versus those other charges?
What I like to look at is the amount that's charged for the dwelling.
But is there a specific term of art that you'd like to use?
No, I've just, you call it rent.
Maybe it's like recurring charges versus usage charges or something like that?
One-time
I was going to also say, some landlords do just an addendum to it. Like, for instance, I asked about getting storage. But I went further and said, okay, so if I need storage for 6 months, but I don't need it for 7.
Exactly.
They were like, you can remove the storage.
It changes, right?
But how many tenants are going to do, again, all of that? So that was very important because, again, is it inclusive or can I come in and out of that? And it was good news that, yeah, you can stop it anytime. So we just did a separate sheet. This is how much it is. You can stop anytime, no penalty.
Storage, Wi-Fi. Some landlords are now offering Wi-Fi around the property. Extra parking, not so much the
Additional
first
parking,
parking. Yeah, the first parking, obviously, in some of the other rent-controlled cities, what they've done is they made sure that you cannot just, do away with pets and then say, oh, you didn't get rid of your pet and now you're going to be evicted. There's certain language like that. And I think with parking, that would be something that the city staff may want to look at because that is something that can be abused very easily. At the same time, though, what we have to be careful of is I think if a judge was to see someone who came in and said, my rent went from $100 for my parking spot to $250, they're going to realize that that's a disguised rent increase to try to beat the 7%. So the other thing, too, is I don't know if it's to the council's best interest for us to comment on every possibility that could be abused by someone. But I think that the parking which you brought up is an excellent example that should be addressed. But, you do have, as my colleague was saying, storage that comes and goes. With COVID, people were doing certain things, and now with gas prices where it's at, people may or may not be driving more, obviously, so they may need that extra parking spot to just park the car and not move it. But I think those types of considerations, when you put it all in one lump sum definition, if your power bill goes up, they can very easily come back and say, you know what, that's an illegal rent increase. Why are you doing that? And the guy's running an Xbox and 4 different TVs in the house, so.
Okay, I think I got it. And I think we can try to capture that prior to our next meeting with some tweaking of the base rent definition to incorporate your comments.
If I may also add something, I've had situations before that, let's say a tenant has left a lot of garbage outside, either in the trash area or outside his or her apartments. And when we pay to remove them, it has to be very clear somehow that the, and if you ask the tenant to pay for the removal costs of all those, that's not a rent increase or anything. It's just, a cost that was incurred by the tenant. So again, it's not, we shouldn't really define every situation in every moment at every time. That's impossible. But a general understanding that if a certain expense is caused by the tenant, then the tenant is responsible, and if the landlord needs to recapture those costs, then it's not an increase or anything. The tenant has a duty to pay those.
Oh, renter's insurance is also a big thing now, too. So if there's a requirement for the tenant to have renter's insurance and the renter doesn't pay it, the landlord will pay for that. And then in the event that there is an obligation to reimburse, they can also charge that against the tenant for the reimbursement.
Is that not negotiated at the?
It can be, but at the same point in time, I just had a situation where the tenant was slow to paying. The landlord covered the renter's insurance, and the pipe burst, and the renters being relocated reimbursed the landlord, but thanks to kind of keeping the policy in place, all their personal property is protected, their relocation is protected. So again, these are the types of nuances that, again, I don't think that this is what the people of the city of Glendale are worried about. It's the landlord coming in and saying, hey, $1,000 for this unit, and all of a sudden 1,000 goes to 1,500. That's what we should be focused on. Let's keep the other stuff out, because then we're just becoming an accounting firm sitting here. And that's gonna be way too burdensome.
I don't think that was the intent,
that,
or that's what's being contemplated. I think the issue about the utilities is an important one, because this does capture utilities, but as you said, the utilities are set by a third party.
Right.
And so the landlord has no control over that. But the other components, like the parking, like the internet, and those other issues, if the landlord is negotiating that with the tenant on the front end, then that's anticipated that that is all inclusive in whatever rent that the tenant pays.
Yeah.
So I think, and then the one-off fees where you've got, you've got a tenant who has made a big mess, or they've brought in a pet when they didn't otherwise have it, and they now need to pay a pet deposit, and that's agreed upon by the landlord and tenant. That's not being addressed in the definition of base rent.
Right, but that's why I said, when you and I were talking, I think we're on the same page on this, because I've seen landlords now add internet. They've taken it from beyond parking to internet, saying, hey, how'd you like internet? $20 extra will include internet, so you don't have to go and sign up and do all that. Well, next month, you don't want them raising their internet when they're paying, $150 for the whole building, and say, okay, your internet just went up to $100 a month. That's not, because again, that's being set by the landlord. So as long as we're dealing with what the landlord is setting
Versus a third party.
versus a third party, I think you've got a protection there.
Okay. All right, can we move on? Next definition is, we could just scroll down this, and then you can ask us to stop if you've got comments.
Yeah, on eviction, I would like to include the word any judicial action, because the service of a notice is technically a prerequisite to an unlawful detainer. And especially if the notice is going to be stated in the alternative, which is correct and you can stay and there's nothing, the landlord's technically not evicting the tenant at that point by the delivery of a notice. But once the complaint is filed, then at that point, clearly an unlawful detainer has formally been initiated, and you can call it an eviction case. Lots of people get notices, doesn't mean they're being evicted.
So we'll take a look at that, because it obviously impacts the sections later where we use the word eviction. Because what this is saying is, whether pursuant to notice to quit or by judicial proceeding or otherwise, you don't necessarily have to go to court. If you're trying to evict someone, you could serve a 3-day notice or a 30-day notice, and then ultimately not go to court and the person's evicted.
Right, but it says it means any action. So hypothetically, I can see this as from my tenant's hat, on a tenant's landlord hat. Hypothetically, if a landlord is serving multiple notices to a tenant, I could construe that as an action taken in towards an eviction that could potentially be harassment. And I would rather leave the eviction to being what an eviction is, which is when the case commences.
It's a judicial
Well, I
process.
think you defined it fine just now, just simplifying it. It's the 3-day notice, et
It
cetera.
says whether pursuant to a notice to quit or by judicial proceeding or otherwise. When we add the
Again,
word judicial action at the beginning,
I don't think that an eviction, if a tenant hasn't paid the rent, or they're in violation of a term of the agreement, the landlord's giving them notice. They're not giving them an eviction.
it's a
I don't
3-day
like-
notice to pay or quit. It's a 3-day notice to perform or quit.
Right.
But that's not an eviction.
But that's not
just-
an eviction, though. That's
I'm
not,
saying we can change that. Yeah.
yeah, that's what I'm saying, is because in the definition, it says an eviction means any action taken by the landlord to remove a tenant. I think that any pre-litigation notice that's required by law should not be construed as an act of eviction.
Okay, we'll take a look at that because it does impact the other sections of the code where the word eviction is being used.
Right, because at that point, the other sections are essentially referring to a point where the lawsuit has been commenced and there's a request for a restitution of the premises.
Not necessarily, because when we're talking about a notice to quit in a retaliatory context, then it's the commencement of an eviction
Yeah,
action.
but that's a regular harassment, violation, retaliation claim. That can stand
All
on
I'm
its,
saying
if
is
you
that
give
we
a
need
notice,
to,
if
we
you
need
give,
to read the definition in the context of how it impacts the remainder of the chapter.
okay.
We can always add another definition for judicial action, right? If,
Okay, we've made a note. We'll take a look at it.
Yeah, because there were even cases that said that a landlord's ability to serve a notice is protected by the anti-SLAPP statutes, that is a precursor that is considered protected speech as part of a judicial process. So that's kind of what I'm thinking.
Okay. Moving along.
So we're scrolling through lease year, non-relocation rent increase, rental complex.
Does rent and base rent need to match up at some point? Whatever you do there, should we have it mirror itself to
They
some
should,
degree?
they should be the same. I mean, it's just unnecessary to have
Since we
two
had
different
commented on the
definitions.
other one.
Noted.
Rental complex, rent increase, rental unit definition, tenant definition.
Rental unit is 2 or more, or 3 or more?
3 or more.
Because halfway through the paragraph, it says, the term shall not include. So, am I missing something here? Oh, 2 or fewer, I'm sorry.
Or exempt.
2 or fewer are exempt, yes.
Correct.
I'm sorry, I read it as 2 or more. My mistake.
Okay. And then concluding with definition of tenant, then we move on to rent increases as the effective date of the ordinance. And then we get to our first red line at the requirement of offering one-year written leases. And I believe this was the slide that you were showing initially, Sipon, is that correct? And again, there were 4 options that staff says that they had heard and
right, 4 options were removing it, updating it, and simplifying it basically, and improving our education and outreach. And then one of the options, Mr. Harpetian brought up, offering a 1-year lease if the tenant accepts, offering another 1-year lease if the tenant rejects it. You don't offer any more leases.
okay.
We should also come to an agreement as to what we're going to do with the different suggestions, because obviously they're not, in agreement. How should we proceed with when we have comments that are get rid of it, or do it this way, or do it that way? What's your feeling of how we should move forward when we have multiple comments on a particular section?
If I may, I think it's a great idea for the first year to have a one-year lease, but.
So the question
and it's
isn't
a-
what's.
Just asking when there's
The
different
question is
ideas.
a process one. If we each have a different idea for each section, what should be the way that we build a consensus around the most,
May I
I
may
guess.
I say something? I don't know if our committee is required to build a consensus. I think you can take all of the ideas. I think there's a consensus of the ones that we agree should be in play, and then have that presented to city council.
But we have to make recommendations, and we cannot offer them four different ideas.
Right, I think council is looking for direction. I don't think council is interested in receiving 4 or 5 different scenarios and then making that
That's
decision.
exactly my point.
I don't want to give them, all these choices. I think if we're at a point where, given the respective experiences and the background of each of our committee members, I don't think we should force feed anybody to agree with the majority or the minority. I think if we are at a point where we say it's just as important to these committee members to say X and just as important to say Y, and we can kind of narrow it down to a very finite set, I think that should, at that point in time, be, if obviously we can reach a consensus, then great. But I don't want to try to sit here and throw my weight around as an attorney and try to intimidate anybody. If my fellow committee members have an idea, then by all means, I think that should go to the city council and they should hear it.
If there is no consensus among the committee members, then we take the democratic route, we vote, and the one that wins the most votes goes forward.
Any other?
What about input from the general public? Is that part of our role to get more of that as far as these types of topics, or?
I think when we get to the outreach part of it, we can certainly discuss how to, these meetings are open to the public. They
Yeah.
know that they're supposed to come and comment. But if they don't, we can at some point discuss how we can identify certain areas and do, I don't know, Peter, what do you think?
I would think that once we get to the ordinance to a point where we've got a proposal that's fairly defined in terms of changes here and there, I think at that point we could solicit the public with this information and then say the next meeting is your opportunity to comment. Maybe you disagree with the definition of base rent. And if enough members show up or express their concern with that definition, then that might be something the committee would have to then reconsider.
I think that's a great suggestion.
So I think we go through it all, we come close to a final type of product, and then ask for, and present to the committee or the public, and then say, what are your thoughts? Come to the next meeting and let us know.
Yeah, I think that's a great suggestion.
All right, so in this particular section, are there any new comments? Something that we didn't capture last time?
.025?
Yes.
I think the only thing that we had briefly touched on was this effective date of the ordinance language.
Is that not in the previous section?
Point 22, .022.
Correct.
Yeah, that was the one, effective March 1,
Yeah.
2019. The thing, though, is if you remember, we briefly talked about, is it the first increase after the enactment? Is it, is it the 14 days? Is it the 60 days? And I know the 14-day provision is coming up. That's why, do we need this language in there? Because essentially, we're picking up from this point forward. If the 14 and the 60 are going to have the same time period associated with it, I don't think you need to have the reference point of when this ordinance was enacted.
I think that's probably right. That was true because as council is preparing to implement changes, sometimes what we see is landlords will rush to increase the rent. And so this is trying to make sure that that doesn't happen. And so this could probably be eliminated at this point, but we'll take a look at it and confirm if that's the case. Okay, now on the 1-year lease, written lease, is there anything that we didn't include in this red line that we discussed, or any new ideas that were not captured from before? Just again, in the interest of time, I don't know that we need to discuss something that we've talked about already.
I honestly think that only 1 year is enough, because basically the 1-year lease offer was to protect tenants from increases every few months. And because now the law says you cannot increase more than 1 time a year, this kind of eliminates that problem. And but it adds something for a tenant that might change his job or his family commitment and needs to move. It's going to tie them down for about a year. So as much as I can see the benefit on both sides, but I think initially when signing a contract with the first year lease, the rest, we really shouldn't dictate how they handle their business, both tenant and landlord. And I believe if there is no lease, it is more to the benefit of the tenant than the landlord.
So last time your comment was to remove the requirement of a 1-year lease altogether. Are you saying that it should only be required 1 time?
No, I'm saying that when they are, I'm sticking with my comment last time. I didn't say anything different now. I'm sorry if I gave you the wrong impression.
Okay.
I don't think after the completion of the first year lease, we have to kind of mandate the landlords to offer another year or another year, because anyway, the landlord can, when on the first anniversary, if he increases the rent, then there is 1 year that he cannot increase again based on the law. So the tenant is already protected from the increases every now and then, every 2 or 3 months. Therefore, it is to the if the landlord offers a 1-year lease, that means we are restricting the tenant, getting the freedom away from the tenant, that in 6 months he or she wants to move to another state, another job, another location. So
If it's the same comment, I think we can move on. If it's the same comment as
it
last time.
was the same comment last time, then that's what I believe. So that means I'm consistent.
Okay.
Can I just clarify, the reference that you make to the new law capping rent increases to once a year, correct?
Isn't that correct? Am I misunderstanding the state law? It says you can only, and this city law, you can increase only once in every 12-month period, right?
To a maximum percentage.
The maximum percentage, yes.
Okay.
You can do
Was
that.
that, is that a question, or
That
was
was my
that a statement?
question on that. And so it's specified, and is that along with the rent control?
AB 1482. That's the
Okay.
law you're
So
referring
that
to,
has an
right?
expiration, if I'm not
Right.
mistaken, correct?
Right, sunsets.
I'd be a little concerned about eliminating something based on a law that would expire and go away
Yeah.
in a future date.
I agree with you on that. I think the last time what we discussed was when you offer the lease to the tenant at the beginning, and then at the end of the term, you offer them another lease term, and if the tenant elects to go month to month, thereafter you don't have to do that anymore. But if they accept the 2nd year lease term, then in year 3, you have to give them another year lease term. The other reason to that is I think with what we're talking about, the rent increase-based relocation, I think that kind of comes hand in hand. That actually fits with the way the city council wrote this in 2019 to say, hey, dear tenant, 1 more year, you can lock yourself down. This is the new rent. Oh, and if it's over 7%, I owe you money if you don't want to take it. And if it's not, then everything else applies. We'll see you in, whatever, 11 months from now. I think that makes sense, especially with all due respect. 1946.2 now has just cause in it anyways. So having a month-to-month agreement, you still put the power in the tenant's hands by giving them the option to accept the lease or not. But this way, you're cleanly walking away from any Glendale obligations, and at the same time, the landlord still can't terminate on a 30-day or 60-day notice anyways, because 1946.2 now exists, whereas it didn't in 2019. So I think that's the safe play. It's pretty straightforward, and if the tenant says, I'm out, then all bets are off at that point.
That would be at least one element I would want to look at to make sure that there's not some way that tenants are losing a protection.
They're not.
By only, I'm not visualizing it, I'm not seeing it yet. And so I'd like to make sure that we go back and look at that and see if there's a downside to the tenant by eliminating a written lease requirement after lease offer number 2.
No, I'm not saying that.
I thought that's what you did say.
No, that's what he's saying. I'm saying after lease offer number 2, if the tenant takes lease offer number 3, then you have to keep offering the lease year after year until the tenant opts out of it. Then you're excused. So let's say after 5 years, the tenant says, I have aspirations to move to Florida. Thank you very much. I've been here for 5 years. You've given me the assurance for 5 years. But at this point, I'm moving. Then they can opt out at that point. There's no rub to it. But if the state law should sunset, which it will at some point, unless they extend it, currently the way it's written, it's supposed to, then the Glendale protections that are afforded to the tenant still keep going as long as the tenant exercises the right to accept the lease.
But are you not saying then if they decline the lease after offer number 1, year 1, offer 1, no longer has to be offered again to the tenant?
No, they're out at that point because the tenant says, I don't want it.
And that's an element I would want to make sure that staff looks at to see if there's a downside to the tenant on that. Because then what protection does the tenant have entering year 2 and year 3 of knowing what their rent will be in advance?
Very simple. It's a rent increase that has to go by California law, and if Glendale's more restrictive, Glendale's ordinance protects them. So that protection, I think, is there. What my proposal suggests is give the tenant the opportunity to lock down their home if they prefer to stay there, and obviously the landlord has to disclose those terms ahead of time. And if they do, then basically it's like you have a first right of refusal. That's all it is.
Okay, so with that being said, I want to make sure that when staff does take a look at that and analyze that we do look at, from the tenant's perspective, is there a downside to that?
Right.
Does it conflict with any of the protections that council had wanted and incorporated into it?
Right. I just had a question for Committee Member Harpetian's proposal. If the tenant rejects the month-to-month and doesn't end up moving to, or the one-year lease doesn't end up moving to Florida, can he ask for a one-year lease later on?
Absolutely.
And would the landlord be required to give that 1 year?
Exactly. And if landlord and tenant decide to renegotiate a new lease, then you essentially hit the reset button at that point.
But the landlord would be required to, if the tenant asks for a one-year lease,
I think at that point they have to mutually contract. But I think, again, look at it this way. Tenant comes back, the landlord says, I changed my mind, I'm going to go with the lease. The rub here is, what keeps kind of the balance is, Glendale now has that 7%, or else you have to pay X dollars in relocation, and what we need to still talk about with what the other numbers are and all that. So I think that's the factor, that if a tenant comes back to the landlord and says, hey, I'd like to exercise that option and come back and do the lease, that once they re-agree, then the tenant's protection essentially refreshes at that point. And from that point forward, the landlord has to keep offering the lease
but no requirements
until the tenant says, I opt out.
As an answer to you, Mr. Zadorian, I believe a lease is a lot more to the benefit of the landlord than to the tenant. The landlord, because he has stability, he knows he is going to get rental payment. He doesn't have to redecorate and the unit for the next tenant, et cetera, et cetera. So a good, conscientious landlord should offer that to a tenant regardless. However, my concern was that after the first, initially, when we were discussing about, not this committee, but before in the city of Glendale, it was to protect tenants from regular and monthly rent increases to the benefit of the tenant. That's why they said you have to offer 1-year lease so that there would be no increases for that year. But when the ordinance already has that in it, state, I don't know when the sunset comes for the state law, but the Glendale law doesn't have a sunset. So if Glendale, we say that landlord, you can only increase 1 time a year, then that's already a 1-year commitment to the tenant that your rent is not going to get increased. And that way, he knows or she knows the rent is not going to increase. In addition, he or she is not bound for the period of the lease.
I think you're misstating the law, though. The law does not say you can only give 1 rental increase a year. I think the law says that there's a limitation on what you can do. Some landlords will say, well, I'm going to do a step up. First 6 months X, last 6 months Y.
But if it doesn't increase more than the maximum, that's already the thing.
As long as you don't go, but let's say Glendale, for instance, has a 7%, and a landlord elects to raise it 3%. They still have an additional 4% that they can raise if they elect to do so.
They are banking it. They are not increasing it 6 months from now.
No.
And if they do 6 months from now, then the maximum is 4.
If the tenant signs the lease, and this is going back to your point, Mr. Zovac, if the landlord says, I'm going to go up 3%, and the tenant takes advantage of that and signs the lease, now guess what? The landlord can't raise the rent at that point, the extra 4%, and would have to go by way of banking. But if they elect to opt out, then maybe the landlord might say to the tenant, look, if you sign a lease, and I did this a lot for many clients, if you sign a lease, it's a 3% raise. If you don't want to sign a lease, it's month to month, it's a 6% raise, because there's an incentive given to the tenants that want to commit to the longer term.
It says for AB 1482, I just looked it up, it says that you can raise the rent twice in a 12-month period.
Exactly.
So that's what you're referencing. So I think Glendale was trying to protect tenants by having them just once in a 12-month.
Right.
Yeah, but then what you're going to get is you're going to say, the landlord's going to say, okay, I'm going to give you a 7% rent increase. Oh, but for the next 6 months, I'm going to abate that extra amount of X dollars. That's the way, that's the simple workaround around that.
Can I just clarify the question about in Glendale, the rent increase 1 time? There could be a step up in the lease agreement. So it could be a 3%, an extra $100 for the first 6 months and an extra $50 the next 6 months. So as long as it's spelled out in the rental agreement itself and the tenant knows in advance and it meets the percentage thresholds, then multiple rent increases throughout the year can be negotiated in the rental agreement.
Well,
minus the state law that went into place, which then you have to read it in connection with state law, then you've got something different.
But I think we've had enough discussion to be able to now to look at this again and look at it from both sides to make sure whatever proposal put forward, we have the full analysis as to whether or not there is a detriment to the tenant side.
By the way, in 28 years of practice, I can't remember the last time I've seen a landlord raise rent 3 times. The only time you're going to deal with that is if you're dealing with an investor that just came in the door, or you're dealing with a total hostility situation. And with the other percentage caps that are usually there, I mean, that's screaming retaliation.
I would say in the height of the rent increases that we were receiving prior to this ordinance being adopted, staff was seeing it on a regular basis.
But that's the whole point is you now have 1482, you have 1946.2, you have this ordinance. So that ability, I mean, look, let's face it, a lot of people were using the rent increase as an indirect way to evict people, essentially. Because there was no cap on that. But you don't have that today. And that's where the concern was back then, which led to this, is you had the market where it was at, you had people that were buying buildings, and they were just jacking up the prices by 50%, 100%, if not more, and it was creating a major issue with that. But I think with where we've come in these years, I think those protections are now there that you physically can't do that.
Let's keep in mind also the illegal rentals. Again, I like to put everything in the bag. We can't assume that everyone is a landlord who's being appropriate in how they're renting out their property. There are a lot of illegal rentals, and we haven't even touched that, where people, this is where we talked about the workshop is good, where people are being evicted and going through their issues with rent and rent increases on a property that is illegal. It's not even listed as a rental, or it's a home being divided up, which I personally know about, and they're collecting rents. There's so much of that, and this is why, again, I'm going back to the email of having the public be able to write in and tell their story of what's happening so we can get an honest picture as well.
Okay.
Because that's a whole nother issue when you're dealing with illegal rentals and landlords who are doing what they want to do at the whim of, their mood.
Okay.
Yeah.
I would say then, I think we've had enough discussion for us to be able to look at these suggestions, especially the ones that might propose eliminating a written lease offer after the first time a little bit more critically then, and then come back with some analysis. So with that, then, moving on to the next section and then our red line.
So the next section is on evictions, and the one specific area where we had a discussion is highlighted in yellow. It's subsection H.
Ms. Verpitio, right before the evictions provision, there was one other comment I had requested last time, which is that that this did not apply to subleases. And the question was, since we're affording lessees the right of tenant protections, why wouldn't you offer that same right to sublessees, who are, when they're essentially now subservient to the tenant, who, for whatever reason, decides to rent out their unit? They should afford their new tenant the same rights that they're being afforded.
I'm not quite sure what you're referring to.
He's
Any
looking at
rental agreement
subsection
doesn't-
I.
Subsection I says that the section with regards to renewal of leases and offering time and security, if I'm a tenant and I want to sublease to you, I can do anything I want. And you as a tenant are up in the air.
But most contracts
It
don't
only
even allow.
exempts sublessees for less than 1 year. So if you're going to be away for the summer for 3 months, we wouldn't require you to make an offer of a 1-year lease. But if you're going to be subleasing for the next 2 years, then you would be required.
Okay, so as you read it, that would cover another 1-year sublease or assignment?
Correct.
Okay, that's fine.
Okay?
Okay, so now we're at 9.30, and the place where we had discussion was in subsection H, but of course, the entirety of the section is available for discussion at this time. Section H, again, we had a lengthy discussion on this, had to do with, Sipan, did you have
May I
a
ask?
PowerPoint on this? Or what do you want to do?
Sorry to jump back on you. Subsection C, the term nuisance. How are we handling things such as, the city of Glendale has certain smoking versus non-smoking. We now have new paraphernalia with vaping devices, cannabis, and things like that. There are tenants that call repeatedly that are concerned about their neighbors who excessively emit certain odors that are disturbing them or their children, or just makes the property in general difficult to enjoy. And landlords really could care less one way or another, but it's a concern, it's a valid concern of the tenant at that point. How do we address that? Because that technically, at least from what I've experienced, I've gotten a lot of calls about that they construe that as a nuisance.
Is that a valid concern? I mean, let me.
It's like
You're-
disturbing the quiet enjoyment of the other person's
Absolutely.
occupancy, and
But I guess I didn't really hear that in some of the examples you provided. And so I
if one tenant is smoking anything and it's getting into the other tenant's unit, then it's disturbing that tenant's use of their apartment.
So, but is that tenant smoking in a permitted area as allowed in the city's smoking ordinance, but it just happens to be bothering that,
No, in their
that
unit.
next door
No,
tenant?
I mean,
In their unit. Their unit.
Yeah.
Let's just say that odor tends to travel a little bit more aggressively than nicotine does, I think. And
So would that be in the definitions? Because there's the paragraph in C, second paragraph defines the term nuisance. And it's typically what you're describing would potentially come up in the context of in court. But this may be the
It could
place
be
where
noise or
be noise, but
odors or
odor.
behaviors that are
this could be
disturbing.
where we can address that in that definition.
Yeah.
that's my point. Yeah, I think the word odor should also be included in that
Because this
definition.
it goes right into gangs and crime, but it can also, a nuisance can be many things, including odors, noise.
Yeah.
So-
A lot of calls during COVID, people that are asthmatic also, this can be very disruptive.
So where we've got including complaints of noise, odor, is this where we want to?
Yeah, you have noise.
Yeah. Older.
I mean, and do you want to specifically spell out a certain, again, this is not my area of expertise, but as far as certain types of products that emit certain odors that are excessive. I mean, if you were to wipe down your entire apartment with ammonia, that could be, it'll be a little annoying for people walking by too.
We could look to see if there's some other examples in other cities,
Yeah.
more current ordinances that may have been adopted that maybe address this issue, and see if we could find something like that.
Yeah.
But you said odor, and then you had some, you had another example, you said something else.
I mean, I guess you could say noxious fumes, perhaps.
You said there's noise, odor, you had another example of, like a good example of what a nuisance could be. Watch the tape back, don't worry.
Good too, it was good, I forgot.
But I just want to make sure we get away from, my boiled cabbage,
No, we're not talking about that.
It could be an odor to my next
Those are some of
door.
the worst ones we
Could be an
have.
odor to my next door neighbor, but for me, it's a delicacy.
Usually,
right?
the dilemma though is,
getting there.
the problem is, the dilemma that you normally see is, we're not talking about your occasional smoker or marijuana use. It's the belligerent ones. The one I can tell you, the calls that I get at least are, the building is just, it's run down because, I mean, it's literally like, it's like a factory going over there.
So,
And it's not believe me, I think that type of user, we can't be ignorant of what's going on out, at least in the United States and in California. So that's not the situation that we're concerned with. We're not here to like bust people with joints.
Okay.
You're talking about the person that is belligerent, doesn't care, keeps their windows open, makes sure to let their neighbors know, hey, look, I'm smoking. And they do it in a disruptive fashion that usually you'll get a consensus of complaints. Rarely have I ever heard of, well, at least again, this is my own personal experience, that's all I'm giving you, someone calling up and saying, yeah, that guy on the other side of the apartment building lit up a joint and I want to evict this person. It doesn't happen like that. It doesn't happen like that. And usually that person that's doing this is also doing other things too. So I think if we define it in the ordinance, at least that gives the landlord or the other tenants a basis of which to approach that person and to give them either a stop it or else before they have to cut the cord.
So what I'm hearing is that there could be some new methods in which someone could be considered a nuisance, and you want us to take a look at that.
Yes, including failure to take care of their pets. A lot of complaints people have that their people are letting their pets defecate or they're not keeping it. Other people are feeding their dogs and their cats better than they feed themselves, and great for those types of people. But unfortunately, there are also people that are careless and they're just letting these animals go out and they're not attended. Even having an unattended animal that's not on a leash is also a potential issue. Okay. You might be dealing with someone that has post-traumatic stress, And that can set them off, whereas if the animal's on a leash, so why do those types of things? Why let it get to that?
Okay, we can look and see if there are any existing ordinances that might have a fresher definition of nuisance with some more current examples that we heard. And if there's something out there, we'll bring it back.
You know, you're paying $3,000 a month, you get a nice building out of it.
Some of these issues are already covered by good rental agreements. So I'm not quite sure if an ordinance that we draw or recommend would really be that helpful. In my rental agreements, I have all kinds of things that a tenant can or cannot do, and quite often, all of these need to be enforcement, and if the enforcement is strong, everything is great. If not, then there will be a lot of problems.
Yeah, as long as we can come back with something that really looks at a real nuisance versus just people being mean to each other, which you can't really regulate.
Exactly.
Yeah.
Exactly.
So, okay, so note taken and moving on then?
We spent quite a bit of time last time talking about subsection H, which was a landlord's good faith effort to recover possession of the rental unit. And some possible amendments that were discussed dealt with the definition of what a qualified tenant should be. This was language that came out of, I think the suggestion was to look at the City of LA definition. There was another definition in the Culver City Ordinance. Both of those are listed here for further consideration. There was another suggestion that that the replacement occupant reside in the unit for a minimum of 1 year. There was discussion regarding the enforcement, and we've captured that. There was discussion regarding the number of units that this could be applicable to, and then lastly, a comment about a rent registry. So all of those sections are things that we had talked about last time. And again, it's not something that we have all agreed to. These were all, some of them are in the alternative. If there's no new comments, we can move on. If there's some, or we can discuss them, I mean, up to you at this point. Again, these are just our notes from our discussion last time.
Right, right. Well, my initial is I don't agree with A at all.
I'm sorry, say that
Subsection A.
again?
With subsection A.
Okay, so this was, that one is being offered to you in two alternatives, right? So one alternative was that, right, A, B, C, that has the definition of qualified tenant, and the second one is, I think, the one that you'd recommended that came out of the City of LA definition.
No, I didn't recommend it. I said that's one of the things that the City of LA uses.
Right, but I think you said that was a good example. Am I wrong in
No,
that?
it's a bad example.
I see, okay. So then we went to your bad example and put it here.
You're saying which one is a bad example?
Health and Safety Code 50072 defines a handicap individual as someone who has any orthopedic disability. Any orthopedic disability impairing personal mobility. And I've litigated cases where the person banged their knee and said, I can't lift my couch. And under that standard, they qualify if they got a doctor's note and said this person has a difficulty with mobility. The other definitions which the state uses, I think, is much better.
Okay,
And that is more equivalent to the type of, I think, disability that people are more akin to hearing about. But this language that's in 50072 is so vague, it's not even funny.
okay.
The other thing, too, I thought that we said, if we're going to replace the tenant, that the landlord can only limit the replacement of not having the entire building replaced with their entire family, but we looked at is that in the red line?
Yeah, it's brought in a little later
Section
on.
5,
Okay.
number of units applicable.
No more than 20%, I believe it caps it at.
I think we mentioned terminally ill, but again, the question is since we're all technically terminally ill, what is there a time?
Well, I think for those types of scenarios, I think we really need to stick, I think we really need to stick with law on definitions and case studies. I'd hate to,
So I agree with the language, but do we want to put a period of time?
It says certified by a treating physician. so-
Right, but terminally ill with respect to an imminent concern, or, if they say they have 5 years to live, 10 years to live, we don't know. Years ago, obviously, when AIDS first came onto the scene, it was horrible with what that was doing, but now with medication and the advancement of science, the life expectancy is tremendous if everything lines up. So I think that, again, what we don't want to do is litigate a person's medical condition in court, okay? I think what we should say is the landlord can take certain people out, have certain limitations so that they don't abuse this language, but at some point in time, you're going to be dealing with people that are in very unique circumstances that should be absolutely afforded a protection so that they're not disrupted in that scenario. And I think that's a hard job for you guys to define.
Instead of handicapped, can we probably use a, serious medical condition or something that, I agree on principle of what my colleague is saying, but handicapped is, by definition, some people might not even like to be considered as handicapped.
I think we can take a look at the state definition and incorporate that as a possible alternative. Now that I understand the City of LA definition was a bad one, we'll strike that as a possible suggestion altogether, and then we'll incorporate that other one in the running as an area for further discussion.
And that serious medical condition can be even temporary, doesn't have to be permanent.
And Ms. Varpinian, is there a way to include language that says that the landlord's basis for doing so was because of the disability? I would like to afford the protection to the person if they have the condition, but let's just say one person is occupying a prime unit with a garage and everything else, and the landlord says, this thing is due. Is the landlord in that scenario really identifying that unit because of the person or because of the
potential
characteristics of the unit? Some landlords might be willing to relocate that person, but they just said, look, that unit's a prime unit. I can't just give it away. As opposed to saying, I got to get rid of this person because they're elderly or they're sick or they're going to fall on my property, and so I got to get rid of them. That type of person has to be afforded a protection. Because then the landlord is essentially targeting them based on their age or some characteristic that you've got here. But if they're targeting the unit because, hey, it's a desirable unit, we've got the scenario that we've got in Santa Monica. We have people with oceanfront 2-bedroom units that can't touch. I don't think that's the intent of what this ordinance was intended to do.
So
Again,
your
remember-
suggestion is to put that as incorporate that as a definition in the qualified
that
tenant?
the motivation or essentially some factor in the landlord's decision is because of the characteristic of the individual. So if a landlord buys a 4-unit building and they want the first floor unit, it's going to be an owner-occupied building, and you happen to have someone who's 63 years of age in that unit, then technically they can't remove that person for them to occupy it, and it's the landlord themselves. That defeats the purpose of what this is really intended for. Potentially, the other option is what if they were also to afford that occupant the ability to re-rent any other vacant units that might be available on the property. That way, you're not necessarily kicking them out of the property. You're just saying, hey, love to keep you, but, you know, can we work something else out?
Do we not say that you can't evict someone if you have a comparable unit available?
That's for a manager, I thought, wasn't it?
Let's see.
Yeah, but I think then you start to get into discussion as to whether an ocean view is comparable to a alley view, no?
Yeah, that is specific to the resident manager. That could be broadened to include, or the other way, to allow them an opportunity to move to a different unit within the, okay. Made a note of that too.
I have actually a concern. Why would this not be under the just cause eviction? If we give additional protection to the elderly or the terminally ill or the low-income tenant, so forth, my concern is that when landlords have a vacancy, they start taking these things into consideration when they take applicants. And if they have two qualified applicants and one's maybe like, one says, I just had a heart attack, or one says that, or one is like, like 60 years old, and then they have another qualified applicant that's, in their 40s or 30s, and they don't have any other issues in terms of what this definition of a qualified tenant is. I mean, doesn't that kind of consciously or unconsciously affect a landlord's decision to who to rent to in terms of, and they're already a protected class, aren't they? I mean, I guess that's a question.
They are a protected class if you're discriminating against it. If there's any sort of retaliatory housing decision based on someone's age, then absolutely, and if you can prove that that was it. But if you have a tenant that's been there for, a long period of time, and typically where you see this is, again, the owner that buys the property, it's a 3-4 unit property, and says, great, I'm gonna live in the front unit and I'm gonna rent out the rest of the property. And you have the person that happens to have been there all that time, and now the owner comes and says, I need you to move out, or I want to renovate, and the person says, you can't move me. Is that something that should be afforded a protection? Because really, again, the landlord is targeting the unit. They're not targeting the individual.
Right.
I'm totally against targeting the individual, 100% on that. And generally, again, you're not going to see someone rent to someone who's, let's say, older. By the way, I'm almost 54, so 62 is not that far away. So
Well,
it's like,
rent a unit and live there for 15 years, and then all of a sudden you're protected class.
maybe I feel like I just realized that. I'm like, wait a minute here.
But wouldn't the relocation, wouldn't that kick in then?
Yes, and I think that's where what we should look into when we come to the relocation. For stuff like this, I think that this language should mirror the other relocation language that we have for the over the 7% rent increases, because that'll give better protection to the tenants in that scenario.
So it concerns me that, you have an owner who buys a property and then your hands are tied and you can never touch this person just because they fall into this definition. That just doesn't seem fair. And then I think that's why we have that relocation.
Exactly.
Language to compensate them for that. To say that, oh, we can't touch them, that does not seem right from a landlord's perspective.
Exactly, but that's why we've discussed the idea of how the relocation comes into the picture, what amount of relocation, which we haven't really gotten to yet, to see how to work that in, so that it's a balance for the people that have been there. So if you have a long-term tenant and you're gonna benefit by, say, a renovation to the unit, you pay them a certain amount of relocation. Perhaps, like I said, I would consider tying the landlord and the renovation relocations to the language that we have with regards to that when you go over the 7%, how you have that 3, 4, 5, 6, that formula that they developed.
Scale.
That scaled relocation, I think, is better reflective of protecting the long-term tenant or the elderly tenant that's been there a while, because they're going to get more, as opposed to just shooting something out of thin air. And that will essentially address what you're saying. At the same time, by putting a cap on how many times the landlord can do this, we make sure that they're not using relo as a way to just clean out the building, which is what the legislative purpose starts out with.
I mean, I see I'm sorry. I see the perspective when it includes specific, age groups. Like if the landlord's trying to take possession of the front unit and the tenant has lived there for 10 plus years. I mean, I see the point there, but in certain disability cases, and specifically when concerning someone that's terminally ill, like you brought up. I mean, yes, we're all going to die eventually, but someone that has a terminal illness, which means an incurable illness, where they're on specific comfort care, generally speaking, hospice care, and are possibly more than likely going to die in the next 60 to 90 days. I don't see how a landlord has any right.
Oh, I agree with you, but that's what I'm saying is, are you willing to, and with all due respect to people that are suffering out there, how do you pick that time period? How do you say to someone who's got 90 days, you're protected, but someone who's got 6 months, you're not protected? Or if you have a year, you're not protected. People may feel that they're going to die in 2 years.
It's not.
If I'm representing that tenant, I would say, why isn't 2 years important? Why is someone that's dying within 6 months? That becomes the dilemma. Is
Right.
We don't want people to have to bring their doctor to court, and there are landlord attorneys out there that will file a case just because they're getting paid, and they're going to force that tenant who probably doesn't have the money to have to bring their doctor to court, stand and swear and testify.
Right, but relocation doesn't help someone that's on terminally ill. How much money are you going to be giving to them?
I agree with you. I agree with you. But what I'm saying is I think that there should be a protection that someone in that condition, someone, and again, there might be other scenarios. Someone could have been a horrific victim of an accident, or it could have been a victim of a crime. You have domestic violence provisions that protect women in these situations as well as men, but you have those types of scenarios. Do you keep that person there if it would be unsafe for them to leave the apartment and go somewhere else? I don't know, but I'm just saying is whatever we recommend to the city council, I think it should have something in there that says, look, after a certain period of time addressing your concern, it's just not fair to tie this up, and the landlord should have to do X, Y, and Z, and both sides just kind of go their separate way.
So we'll go back and take a look at the state law definition that addresses that. We'll incorporate that. We're now 2 hours into the meeting. We're probably at a natural stop with this section unless we want to continue to discuss it. We can come back and pick up from this spot here next time rather than go back and start at the beginning.
And Ms. Varpetian, one thing I think it's important also for the public that's watching to also understand, when we 20 years ago tried to do the Just Cause Ordinance, we didn't have it televised. It was, the meetings were in one of the
MSB.
offices. But we were spending hours upon hours, and we had many sessions, because the difficulty is trying to reach a consensus of this, because you want to be able to close this, move on, and let people go on with their lives without having to have this come back and bite them. So that I think is important.
Yeah, of
because I've
course.
had family tell me, oh, those hearings are so boring. And it's like, yeah, it is, but unfortunately, we've been asked to kind of throw some suggestions out there, but this process just does take time.
So if it's okay, we probably want to stop the discussion here because I think
Lucy,
we want to have two specific things. Number one, I think there's a response to a question that came up last time with regard to certain numbers. Let's answer that.
Yeah, committee member Gregorian asked if we had any specific numbers on evictions and how many were related to family move-in or manager move-in. We had about 88 specific questions that the public asked, how do we go about this, things like specific questions. There was about 88 of them, and 39 of those 88 were related to family moving, so about like 45%.
I'm sorry, can you, I didn't get it. Can you speak a little clearer, please?
Sorry. Last meeting, you asked if we had any numbers regarding evictions and how many of them related to a landlord asking for a family member to move in or a manager to move in. We looked at our numbers and we had 88 eviction questions where a landlord or a tenant specifically asked, not general like, oh, does the city of Glendale have an eviction protection, but specifically asked questions. And 39 of them were related to family move-ins, and about 42 were major rehab related. It's about 45% family move-in related type of questions.
So that was over a year?
Yeah, over the last year.
So if I understand correctly, there were 88 evictions.
Questions related to specific evictions where someone was saying, I'm getting evicted, and this is the reason I'm getting evicted. We had more general questions that someone might have called and said, am I protected for this kind of eviction? But these specifically said, I'm getting evicted tomorrow. This is my this is the reason that I was given for the eviction.
And of those 88 questions regarding eviction, 39 were allegedly the landlord wanted to move them because they wanted to move their family members in there.
Right.
Okay. And so compared to all these rental units that we have in Glendale, that's quite a small number. Correct?
Well, this number doesn't represent every single eviction in Glendale. It's just the ones that contacted us.
That's
people.
exactly
Do you
what I
happen to
was.
know, were those 5 units and larger, or we don't even know?
No, a lot of times if we dig into it, if we ask them questions, we're helping them out, we might get that information, but sometimes they don't really tell us where the unit is.
Okay.
But we can go back and look, see if we collected that
And
information.
I know I may be asking a very difficult question, but do we know how many of these 39 cases were actually genuine and how many were just an attempt by the landlord to move the tenant? Do we know?
I can follow up to see what happened with these cases, but I can't tell you right now if the landlord was genuine or not.
I really don't want to put you into a lot of headache and effort to get nowhere. If you can, that would be great.
I mean, either
However-
way, it'd be difficult to say if the landlord was being genuine or not unless we follow up with each landlord and see who they moved in after the eviction. And that's going to be difficult to contact each landlord and say, did you move your...
That's exactly why I didn't want to put you into that predicament. But the issue is, so there are some landlords who want to move or move their the relatives or whoever in there. Mm-hmm. And the main question that I was asking is, quite often these are mom and pop landlords, maybe senior citizens who sell their home and want to move into one of their units, or somebody who wants to move their parents into one unit. So there should be, I mean, if we do have the statistics, I don't think that anyone who wants to move his or her elderly parents into one of his or her units, I don't think that's a crime. That's actually a great thing to take care of your family. But, I'm more interested in the number of abuses than the genuine, needs.
Can I say something too, real quick? We have to go back to what I've stated continuously, is everyone does not call in.
Right.
Just like everyone doesn't report a crime.
That's very
So
true.
please don't take these numbers and be like, oh, that's so low. No. And there's other places like Glendale Tenants Union where people call in. There's other grassroots organizations where people are leaning into.
That's very true.
I have guided many people to Glendale City that don't even know to call. So this is why, again, we're talking about the workshop is really important and different things like that. So it's a low number, but that's what they've captured. That doesn't speak to the entire city of Glendale. So we got to keep that in mind too. And that's what we're here for, right?
Absolutely, I agree with
This is what we're here for.
Do you have, by the way, do you have any numbers on the other 3 sections with regards to the relocation, that apply to that relocation?
how many questions they asked regarding relocation and things like that?
Yeah, no, for instance, any relocations that were initiated because of an issuance of a governmental order, the remodel one, and what was the last one?
Yeah,
42 for remodeling, and
and
then
7 for breach of lease, tenants' potential breach of lease. We have 122 general inquiries on evictions. Question 589 about relocation and AB 1482. 142 about the 7% increase.
and this is in what time frame? Are the 1 year?
Yeah.
Okay.
And that was COVID year with an
Yeah.
eviction
We had
moratorium, correct?
1,078
Yeah.
questions on.
So it goes to the comment that it's not really a true
Right.
reflection of.
500, what did you say, 589 were about the,
Rent increases on AB 1482 and about 1,078 on specifically COVID. And that could have been related to how do I get the
Rent
rent
relief.
relief?
yeah.
Can my landlord increase the rent? Do I have to move? I got things like that.
I
Just
was probably
specifically.
20 of those calls myself.
Yeah, the numbers are a little skewed because of COVID, because majority of the calls we got were related to COVID. And it's more recently that we're getting.
Yeah.
So Lucy, can you go back to where you thought a logical stopping point was and then continuing to the next meeting?
Probably here, I think what we should do is look at the remainder of our agenda. We had one item which we probably won't get to at the next meeting, given the discussion that we're having today, but we will include that on the agenda for next time, just in case, which is, we always want to include more on an agenda in case you get through something quickly, and then we can move on to something else. So that item will come back, the discussion regarding past outreach efforts. There's a PowerPoint on that. And so I think now would be the committee and staff comments, if we're ready to go into that. I do know that from staff's perspective, we wanted to discuss the next meeting because this is our June meeting, the continuation of that one meeting that we canceled. So if you want to read the next item into the agenda, that's staff comments, and then we can open it up to other comments as well.
So item 6 is the ad hoc committee members and staff comments. Members and staff will have the ability to make comments, and at this point, we'll ask, are there any committee member comments on anything not on the agenda? And if not, then staff does have one comment with regards to what Lucy had just mentioned, would be our July meeting. I think at our last discussion, we had talked about the fact that there might be a number of people that would be taking time off at the end of July. And so that's why we felt that we needed to expedite and have a June meeting in early July. And so the question would be whether or not there's a continued feeling that the end of July meeting, and that meeting is July 27th, whether there'd be enough attendees to have that meeting, or should we just default to the next meeting in August?
I was under the impression that we chose the second one, like we skip 1 month in here, so July, and do the June meeting 1st of July, and then the next meeting end of August.
Correct.
That was the impression I got, and of course I go with what the committee members and my colleagues say, but if it is anything in July, after I'm leaving the
Couple
country
days.
on July 11th,
Right.
and coming back August 19th. So with all due respect, between these 2 dates, I will not be available, but if my colleagues choose to move forward, I'll be very respectful to that.
Right, and that was the discussion we had and the concern we had, and of course.
I actually have a medical procedure on July 25th, so I wouldn't know until the next day whether I can come in or not. So I think August would be better for me as well.
Okay.
So then I think what we would do is, if that's okay with everyone else, the next meeting would be on August 24th, rather than scheduling something between now and August 24th. We will just wait until August 24th as our next meeting.
So a regular meeting of the committee on August 24th, okay.
So can we make sure, again, I think this is what I've heard from a couple of people, that they are hoping our meetings can stay pretty consistent. And I do remind everybody, we're a work in progress. Listen, just be patient, we are a work in progress. But also, at least to make it known publicly that the meeting has changed, it's going to be forwarded to this date. And again, I think the email will help, but definitely at least publicizing the change of date for our committee.
So moving forward, I think we're just counting on meeting on all of our regular meeting dates, which is the fourth Wednesday of each month, starting at 6 p.m.
By the way, is virtual attendance still even an option?
No.
No.
Okay.
Are the announcements of these meetings on those same email alerts that the city council? Because I get the city council ones, but I don't know if these are.
No, so for each legislative body, you would have to request to be on the email list to receive agendas.
Okay.
You get it because you are on the city council, you
Well, I
must have
signed
made
up
it.
for the other ones. I guess we should tell people that they need to sign up if they.
And they could do
also-
that online.
Yeah.
And then they would just get on the email notification,
Right.
and every time the committee gets meeting notices, they would get that as well.
But you also have it on your website, our
Correct.
meeting in advance?
Correct.
Yes.
Okay.
Yes.
And do we run PSAs on GTV6 and all that? Because I think that's quite important. Not that everybody watches GTV6, but you know what I mean.
With the considerable break, with not having a July meeting then, or end of July meeting, that might afford us some time to formulate and maybe send out a little bit more information to the community about the upcoming, maybe about the work thus far, and then the August 24th meeting. And we'll see what kind of reaction we get.
And then just by way of preview, we'll go through the remainder, and then we'll go into the outreach efforts, and then we'll try to make sure that at some point we try to come to a consensus, if we can, on the different alternatives that is being proposed.
Can we also consider, I know that televising it would be a problem, but can we consider somehow maybe an extraordinary meeting or something to organize, let's say, in a community center where the community can participate, like, the adult rec center or the Maple Park Community Center or something. I really would like to see the community and the members and especially the renters to be involved and make their comments so that we can try to accommodate and get more knowledgeable about their concerns.
Actually, you hit on it in the very beginning of your remarks. It's the ability to broadcast. And there's not that ability to do it outside of chambers.
Broadcast, or it has to be public?
It has to be broadcast.
It has to be broadcast.
Correct. Correct.
Okay, so,
I was under the impression that as long as the public knows and it is public and open, I thought that was okay. But if you say I have to take your
that's
word.
a policy of the city council, that all.
Oh, that's a policy, not the law. Okay, that's fair enough.
The law does say that they have to be open and noticed and all these other, but then the city council also says that all committee meetings have to be televised.
So is there any way that, noting that, we might have an extraordinary meeting, not this, but with the community? Well, let's go to the community and find out what their feelings are.
Perhaps the next time we do, when we go to council with a status report, we can ask if they would be
If my
amenable to
colleagues
that.
agree with me, I think that would be a good idea.
Well,
Well, I think that if the public does have the ability to make their comments in these meetings too, I think we just have to, unless you're following, you're signed up for the agendas, it's not easy to, you go on with your life and you don't remember when the meetings are, and then so maybe I think if we could have a lot of publicity about these meetings and they could make comments here, that would be effective.
Yeah. Well, the main purpose is to have more participation from the public. That's what
We need like
looking
a slogan or something, like
well,
Jeopardy's too hard, watch us.
yeah, and I think you might have more of an idea about some of the challenges we have with outreach efforts when we present the outreach effort report. Because the question would be, is there really a community location that would generate that type of response that you think is out there? And I don't know if there is.
Give
And we
away
could
free
talk
ice
about-
cream. Give away free ice cream and they'll all come out in
Well,
droves.
Well, city council, do they mention us, or can they mention this committee during their meetings?
You can certainly reach out to council and request that during staff comments or council comments that they mention that.
Yeah.
Good, they would be good public
But
relations.
I think unless it's a brand-new house being developed right next to you as part of the planning commission design review, I think every other committee is struggling with the same type of concern, even at council level, I believe,
That's true, yeah.
of getting that participation.
My only concern.
Item on the agenda, Peter.
If we're still in comments at this point, right?
Yes.
My only comment would be as follows, is really, the first thing that we're kind of been grappling with in the last couple of meetings is identifying when, how, and what constitutes a problem. And that's, or how are we supposed to define certain things? And that's what takes up tremendous amounts of the time. When I look at where we're at in the ordinance and the remaining portions that remain, the remaining portions are how you address or deal with it once you've defined it. This is always going to be the hardest part, no matter what you do, because it's a question of, does this fall on this side of the fence or the other? From here it goes forward, and then you get to the last point, which is what your concern has been since the first day we met. Now that this has all kind of been ironed and set aside, how do you tell people about this? Because that is really where the work comes in. And okay, so you now have this and you have these rights and so on and so forth. This is good, this is bad, you know, don't do this or you can do that. Then what happens? And I think that we should at some point in time focus on that, because what good is it to say you have the right to a lease and after you opt out, you're done, you're out, and if you don't respond within 14 days or 30 days, it's considered a rejection. And they don't know that. What happens is the landlord's gonna send the letter, or they're gonna hire a lawyer to send the letter. Tenant's gonna go, I got some time, I don't know what's going on. With all this COVID mess too, that doesn't help us here in the city of Glendale, because people are just confused in general. They're not gonna realize that the city of Glendale has enacted an ordinance which has repercussions to it. And then all of a sudden, they fail to act. And then what's gonna happen? They're gonna come knocking down on everyone's door saying, you know, what's going on? And let's face it, any lawyer is looking for the angle. So once they get the angle, they're not gonna let go, because they're gonna say, ignorance is not a defense to the law. So that is gonna be a very important element that I think the city, if all this is gonna mean something, I think ultimately, they have to kind of come to the rental rights center or to the lawyer's office with some understanding already. You know, you can't make a right turn at a light that has a red light that says no right turn. You gotta know the basics, and if you know that, then the rest will kind of follow, so.
Sure. Any other comments? Seeing none, we'll move on to new business. We do not have any items on in this area, and then if that's the case, then we'll move on to adjournment. Entertain a motion to adjourn.
So I move.
Second.
Second.
We have a motion and a second. No objection, we will adjourn at, can't even read the time from here, what does that say? 7:49.